is being recorded. So everyone who attends tonight will have access to this recording indefinitely. And through the private YouTube link, again, please don't share that. That is just for you to enjoy and kind of refer back to this later. We are anticipating roughly 80 families from Birch tonight. So if on your screen, if you're like, why can I not even see anything because there's like hundreds of people on the screen, that's why. But there's probably a setting that you can kind of tweak on your end. So here is the plan for tonight. So first of all, if you thought this was about how to make organic pumpkin pie class at Birch, you are at the wrong place. If, however, you are interested in the topic and subsequent concepts in and around estate planning and wills, you are absolutely in the right place. So for the first hour, Steve Bennett will be working through his content, and I'll introduce him in just a moment. And then the second half an hour, 45-ish minutes, will be for Q&A. So please, if you can, hold on to your questions for that time. So let him work through the content, and then we can get after all your questions as best we can. He is not going to write you an estate plan and will during your question. So if you ask that, unfortunately, it's going to be a no. We'll have to figure that part out later. If you do have questions, again, feel free to use the chat as we go through. Also, Becca and Tina are here tonight to help kind of manage this epic group of lovely Birch families. So if you have any technical questions, don't call them in the middle of this, because that would be really difficult for them. Google Voice text is fine, an email is fine, or just private chat them will work great. All right, with that, I would love to introduce you Steve Bennett. Steve is a Portland-based estate planning and as well as a bunch of other things lawyer, and he's been in the business for 44 years now. Specifically, the last 20 years have been focused on estate planning, creation on the front end, and then administering said estates on the back end when an event takes place. He's have a relationship to Birch for several years now, taught this class multiple times in person before I got here, and then a few times when I was here, and then when COVID happened, took a break. But his extent of experience and knowledge is quite epic. So I would encourage you, if you have a question, do not let this time go by, because he is not charging you per question. So if you have like 8 questions, feel free to put it in the chat, but we might not get to all 8. I'm going to try and not do any more lawyer jokes. All right, with that, Steve, it's a pleasure to have you. Thank you for being here, and please feel free to bless these families.
Okay. Well, thank you, Dino. Great introduction. I'm happy to be here and sharing this important information with you all. There's a lot of information, and hopefully most or all of you have seen the written materials that I provided ahead of time, and we're going to work our way through that outline. It's really a discussion outline, and I wrote it so that you could kind of make notes along the way. And but we are going to have a lot of detail, so I'm going to try to move right along. And there may be things we won't cover that you're interested in, and it may be that you'll want to send me an email afterward, and we can follow up that way. So for starters, a lot of people wonder, what does it mean to have a will, and what exactly is a will supposed to do? Well, now we all know a will is theoretically just a document that gives away your assets upon your death. But it also allows you to do some other things. And these are the other reasons for having a will. Number one, choosing who should be in charge of your estate. In the movies, they call that the executor. In real life, that's right, the movies aren't exactly realistic here. It's called the personal representative. And oh, by the way, when somebody dies, there is not the reading of a will with all the beneficiaries in the room and dramatic music in the background. That's kind of a Hollywood invention. So your will can name who is going to be the executor or personal representative, and we call that the PR. And the PR is going to manage your estate during the administration process, meaning the period where your estate's going through probate. Your will can also state who you prefer to be the guardian for your minor children. And that's important because the court has a lot of discretion, but it's almost always going to follow the preference that you state in your will, unless you happen to pick somebody that's terribly unqualified. Another point in a will is describing how your debts are going to be paid, how your taxes are going to be paid. In other words, from what funds. And then you can also express preferences about memorial services and disposition of remains, like whether or not you want to be cremated and that sort of thing. Now, anybody can have a will, can sign a will if they're over age 18 or if they're married, as long as they're of sound mind. Some people would say that if you're around age 18 and you are married, you must not be of sound mind, but that's a whole other issue. So to be valid, a will has to be signed by the testator, we call it, the person that made the will, but it also has to be witnessed by two people. And then the witness signatures have to be notarized. This is important because a lot of people think they can write out their will and sign it and get their signature notarized and they're done, but it doesn't work that way. There's a lot of history here. Excuse me. A lot of history about the formalities of signing a will, and you have to follow those very strictly or the will not be valid. So what happens if you die without a will? We're now at the top of page 2 of my outline. So a lot of people are worried, well, if I don't have a will, does that mean everything goes to the state? And the answer is no. There are default rules that apply even without a will, and they're pretty common sense. They say, you know, if you don't have a will and you're married, everything passes to your spouse. And if your spouse is gone or not, you don't have a spouse, then everything passes to your children. So it's kind of like where you'd want things to go anyway, at least in most cases. If you don't have any children, things go to your parents. And if you don't have parents around, things go to your siblings. And that raises some eyebrows for some people because they don't want their stuff to go to their brothers and sisters. But that's the reason for having a will, is you can override the default rules. And that way you can specify who that PR is going to be instead of letting the judge just randomly pick somebody to be in charge of managing your estate after you die. So then the assets are given out. Well, I think I already mentioned how they pass without a will. But the other thing about not having a will is probate is slower and more expensive. And we're going to talk more about probate in just a moment. But just remember that having a will not only lets you say where stuff goes and who's in charge of your estate, but it also speeds up the whole probate process. It makes it cheaper and faster. So moving on to item 3 in my outline, the additional documents that we almost always prepare at the same time that we do a will for somebody is, number 1, a financial power of attorney. That's a document that allows somebody to manage your financial affairs for you while you're still alive. Say, for example, if you are incapacitated. So if you're, in a hospital bed and you're in a coma, but somebody needs to mortgage your house to pay for the life-saving medical procedure, that's a good idea to have a power of attorney so that you can appoint somebody ahead of time to have the authority to do that. A lot of people don't realize that a power of attorney is instantly revoked upon the death of either party. So in other words, the person that grants the power of attorney has to remain alive. And of course, the person who's given the power of attorney has to remain alive. And as soon as even one of them is gone, then that power of attorney is null and void. The good thing about a power of attorney is that it avoids the need for the alternative. The alternative is a court process called a conservatorship. This is where the court appoints somebody to be the conservator in charge of your financial affairs because you lack the capacity to manage your own affairs. So that's an expensive process, very slow, very cumbersome, lots and lots of red tape. And that in itself is a great reason to have a financial power of attorney, and that is to avoid a conservatorship. The next document that I've listed is a medical disclosure authorization. This is also known as a HIPAA release. It's the form that you sign that tells your doctors and other medical providers who they can disclose information to. So naturally, you'd want to list your spouse on this form, maybe your adult children, maybe some other favorite family members or friends. And that way, the important people in your life can learn what your prognosis is or how long you have to live if that situation arises. So it's important to have the medical disclosure authorization. And then finally, the sort of semi-famous advance directive. This has been called a lot of different names. Some people call it a power of attorney for healthcare. It used to be called a living will, but that name got really confusing because it sounds a lot like other things. So we don't call it that anymore. In Oregon, it's called the advance directive. And it's the form, it's a pre-printed Oregon form that you fill out and you sign. And it allows you to appoint somebody to make healthcare decisions for you if you're not able to. And that's helpful, of course, because you might be in bad shape and the docs want to know if they should do a certain medical procedure. And if you've appointed somebody ahead of time, they can make that decision for you. The other important thing you can do with an advance directive is you can make some decisions for yourself ahead of time. So for example, I do want tube feeding and I want pain meds. I don't want hydration because it's painful, things like that. But the most well-known decision that most people make for themselves ahead of time is, hey, if it's hopeless, pull the plug. Don't keep me artificially sustained, right? That's the famous decision that originally was made famous by the Terri Schiavo case out of Florida. For those of you that remember that years ago, a woman was critically ill, but her family kept her plugged in, so to speak, and it was a very hotly contested situation. So this is a great way to avoid that by having an advance directive. So that brings us to the subject of probate. What the heck is probate? It's it's really nothing more than a court process. It's like any other court process. It's like filing a lawsuit, only you're not suing somebody to get money. You're filing a proceeding with the court to get the court to help you manage an estate. So when you go through probate, you're filing a bunch of forms. You have to report and notify a bunch of different people. But at the end of the probate process, you're getting the court's blessing on what you've done during the probate and what you get to do with the assets at the end. Now, in Oregon, as in most states, and by the way, a lot of what I'm saying is very true for Washington as well. So for those of you that have Washington connections, most of what I'm saying is exactly the same. In Oregon, we have two flavors of probate. We call it probate light and then main regular probate. So my outline under number 4A refers to the small estate proceeding. And this is available. It's a much simpler, streamlined process for just what it says, smaller estates. You can see I put in the limits there. The real estate cannot have a value of more than $200,000. So if a decedent died owning a house out in the country and it wasn't very valuable, then a small estate proceeding might be available. The decedent also could not own more than $75,000 in personal property. Now, personal property means anything other than real estate for these purposes. So that's bank accounts and cars and, collector things or whatever. So those are pretty small amounts. And in today's world, most people have assets that exceed either or both of those categories. So we're finding that it's pretty unusual that the small estate proceeding is available, but it's something to know. it's available if you have the right circumstances. And it really just entails a single filing with the court. It's not very complicated. And once you file this thing with the court, you wait 30 days, then you get a certified copy back, and then you can go around and show that to all the banks and whatever to get the decedent's money released. But like I said, that's pretty unusual. So we have regular probate. Now I'm at the top of page 3 of my outline. The regular probate process is no doubt lengthy and expensive. There's just no getting around it. And you might wonder, why does the law make it that way? And the answer is because there's a lot of interested parties that could be at a disadvantage if there wasn't a legal process to protect everyone's interest. So when you think about it, there's not just the family members who are waiting to inherit money. There might be creditors who are owed money by the decedent. There might be government agencies that are due reimbursement. For example, the taxing authority, they like to get paid. There might be ex-spouses. There might be distant children that maybe aren't really connected anymore to the family, but they are entitled to notice if they were a blood relative of the decedent. So there's a lot of people and interested parties that can and should get noticed. And that's what probate is about. It's making sure that all the interested stakeholders, so to speak, get notice and a fair opportunity to sort of raise their hand and ask questions and get information. So probate takes, in Oregon, anywhere from 4 months is the very fastest it can be. Typical probate time is 5 to 8 months. Now, during that period, whoever got appointed by the court as the PR, or what the movies call the executor, that person is in charge of managing your estate. And they're not frozen. In other words, they have some flexibility, some leeway on using assets of the estate if they're needed to. For example, there is a widow allowance. That means the surviving spouse can get access to the decedent's money even before all the necessary waiting periods. That's just one example of many. So a lot of people have this image that probate, freezes everything. Well, it does to a limited degree, but we can work around that. And so it's rarely a problem. The cost in Oregon is unfortunate because it's expensive. Even a relatively simple probate that goes smoothly will probably result in legal fees of $3,000 to $5,000. So it's expensive. And some people think, well, shoot, if I could do a do-it-yourself divorce without a lawyer, why can't I just go to probate court and have a do-it-yourself probate? And the answer is the law has a very, very clear rule there that no probate can proceed without a lawyer representing the personal representative. So there is no workaround, unfortunately. It's sort of a necessary evil of the system. When probate starts, one of the things that the law requires is the publication of a notice in the newspaper. And I don't know if you've ever seen that, but in the Daily Journal of Commerce, that's the newspaper where we publish notices, there's notices of probates. And I mention that because what a lot of people don't realize, when a probate starts, that notice gets published in the paper. And if you're the PR of an estate, say you're responsible for managing this estate, maybe you're managing even the family home where your parents lived and then they're finally passed away. Keep in mind the bad guys read those death notices also. We've had a number of clients report to us that after the newspaper notice came out, their house got vandalized because the bad guys learned that mom and dad were gone and the house was empty, and they took advantage of that. So it's something we try to warn our clients about every time. Let's see here. There's a court filing fee involved with probate. That's usually not huge, usually around $500 to $600. And there's that whole time thing. But more importantly, there's a lot of filing, a lot of paperwork. And that's why you have to have a lawyer involved, because they have to help guide you through filing all these different documents. One of the most important things is that the probate process is designed to do what I call bring order to the chaos. You know, when people die, it seems like there's a whole bunch of chaotic questions about, you know, finding the assets and valuing the assets and making sure the right people get the assets and not the wrong people. So that's what all the things, that's what probate is designed to do, all those things, is to create an orderly liquidation of the decedent's assets, make sure that valid debts and bills get paid, provide an accounting so that interested people can figure out what exactly happened during the probate, and then at the end, distribute the assets to the rightful heirs and beneficiaries. So if you want, we could take a couple of questions right now. And, you know, I guess you're kind of keeping your eye on the chat box.
Yeah.
Okay.
So families, go ahead, and if you've got specific questions up to what Steve's talked about so far, feel free to put it in the chat. If you're like, I don't know how to ask this because it will take me like 3 minutes, try not to get into that specific of a question. But if you're like, hey, talk to me about like, where do I go in the, who do I go to? Who's the first person I call in the probate process? Or is something like that.
Hey, Dino.
Hey, Ron.
Hey, the chat is disabled.
The chat's disabled?
Yeah.
It's interesting.
But I do have a quick question.
For it.
So you had mentioned that the probate cost is about $3,000 to $5,000. What's the cost to have an attorney put together a will for you?
Okay, the question, hopefully you can all hear me. The question is, what does it cost to have a will prepared? And the answer is that, you know, it really depends on the complexity. It's kind of like going to a contractor and saying, build me a custom house. What's it going to cost? Well, the contractor's going to say, oh, it depends on how many rooms you want and all that stuff. So the same thing with a will, but I can give you the answer this way. Most people follow a pretty predictable pattern in their will. Most couples do, most individuals do. And if you follow that pattern where you want to leave things to the obvious beneficiaries, the wills can be pretty inexpensive. I think there are lawyers out there that will prepare a simple will for $400 or $500. And I realize that's still a lot of money, but it's not as expensive compared to what more sophisticated clients need. You probably can imagine, I represent a lot of high net worth individuals that are my age, and they tend to have more complex wills. And you know, we prepare complicated wills for those people, and they might cost $2,000 or $3,000. But for most people, a simple will maybe $400 to $500, $600, and that's often done for a couple, a married couple. In other words, a will for each husband and wife. And so there's some efficiency there of doing them both at the same time, of course.
Ron, we got a couple of questions about personal representatives. First one is can they be out of state?
Good question. Can the personal representative be out of state? And the answer is yes. They can be anywhere in the US. And I actually just wrapped up a probate where my personal representative was located in Japan. So they can really be anywhere. But most typically they're somewhere in the United States, and we represent people everywhere.
Thanks for that. There's another question about PR around the fees for the PR, and the question is what is the PR fee paid to the executor in Washington versus Oregon? So is there a difference between the cost to be a PR in Oregon versus Washington?
There is, and I'm apologizing because I don't know the exact details of the Washington statute, but I know it's similar to Oregon in that it's a percentage of the estate. So if you're the PR of a very small estate, the PR fee is going to be small. It gets paid to you out of the assets of the estate if you're the PR. for larger estates, it's more significant. I can tell you that in round numbers, it's roughly $1,640 plus 2% of everything over $50,000. Round numbers, it's about 2.5% of the estate. So you can kind of guesstimate based on how big the estate is. But there's an important drawback to taking the PR fee. Most PRs waive their right to receive the PR fee. And the reason they do is that they're also an heir, they're a beneficiary of the estate. So let's see, could they get their money by inheriting it, or should they try to get their money by being paid compensation as the PR? The latter, in the eyes of the IRS, is earned taxable income. Guess what, folks? An inheritance is not earned taxable income. So everyone's way better off if the PR, who is also an heir, is going to just inherit his money rather than get paid for being a PR. But that's a simple rule to follow. And there's, of course, exceptions to that.
Steve, what are the inheritance caps if a family of Birch inherits X amount of money? At what point are they responsible for taxes?
So there's different taxes involved. The two main categories of taxes that come to play here are income taxes and estate taxes. So let's just talk about estate taxes for a moment. It's a simple one. It's the one-time tax on the amount of wealth that you own at death, right? Just one time only. And basically we add up the value of all your assets at death and subtract out your debts, and whatever the net amount is, that's what gets hit with the estate tax. But there are exemptions. So at the federal level, there's a whopping $12 million exemption. That means you can die owning up to $12 million and not pay any federal estate tax. Okay, probably doesn't apply to most of us, but that's the rule, and you can reflect on the social benefits and detriments of an exemption that large. Trying to put things neutral. So the other tax to know about is the Oregon estate tax. The Oregon estate tax has an exemption of only $1 million. Still a lot of money, but keep in mind that when we're trying to analyze whether your estate is over the $1 million exemption, we got to consider everything under the sun, not just the obvious things like your household equity and your money in the bank and things like that, but also life insurance death benefits. So if you have a life policy on your own life, even a term policy, and it's going to pay $500,000, then you're halfway there to the $1 million exemption. Another example is retirement accounts. A lot of us put money into a retirement account, and over the years, it gets pretty significant. If you add all those things together and you're over $1 million, then the part that's over the $1 million gets hit with the Oregon estate tax. Now, the Oregon estate tax starts off at 10%, and it stair steps up to 16% for larger estates. But on average, you can figure it's about a 12% estate tax. Very similar to Washington, but some of you will be reaching for your car keys so you can move to Washington when I say this. Washington has an exemption that's doubled what Oregon's is. So in Washington, you can die with $2,193,000, and that amount is all exempt. So Oregon's got a little disadvantage by having a lower exemption amount. The tax rates are roughly the same in both states, on average about 12%. So those are the state death taxes.
Thank you. The questions are rolling in. Can a person write a will on his or her own?
So the answer is yes. And for whatever reason, the law calls that a holographic will. It doesn't really seem to apply, but that's the name it's given. But the key is this: you can write your own will, but it still has to follow the formalities of signing and witnessing. So that means you can write out your will, you can type it or handwrite it, and you date and sign, and then you got to have two witnesses who were present when you signed. Those two witnesses have to sign an affidavit saying they witnessed you signing the will, and they sign the affidavit, and the affidavit has to get notarized. So there are a lot of formalities, but yes, you can write your own will. And there are self-help websites that will walk you through those requirements.
One of those questions similar to that, Steve, is LegalZoom reliable?
LegalZoom has a lot of pluses. Now, it's not perfect, but in many cases, what you can achieve through LegalZoom is way better than nothing. And nothing is what a lot of people die having in terms of their estate planning documents. They didn't have anything, and there's a little bit of chaos there. So yes, making a good, intelligent attempt through LegalZoom to have a will and these other things, documents that I'm talking about, is way better than nothing. Yes.
And you might be, another question is around how to avoid probate, specifically with trust. Are you going to touch on that a little bit?
Yes, that's
Okay.
that actually is coming up.
All right, so I will skip that specific question. Someone asked, I know about probate because I went through this epic challenge when my mom passed. Do we need a living will or a regular will?
So a living will is a very misleading term, I believe, because a living will technically is the advance medical directive. It is the form that you sign to say, here's the medical decisions I'm making for myself. That's what a living will is. A will to dispose of your assets is sometimes called a last will or just a will. But then a trust is a whole other animal, and we're coming to that next. So we could slide into that if you'd like.
Yeah, we'll pause on questions and then go ahead and jump into that.
Okay, we're now in section 5 of my outline. What are the alternatives to probate? So yes, you can avoid probate. Couples often do this by jointly owning their assets. Most typically it's their house. And what that kind of joint ownership can achieve through spouses is avoiding probate on the death of the first spouse to die. In other words, the ownership of the house automatically passes to the surviving spouse simply by recording a death certificate at the county recorder's office. So it's a very simple process, it's immediate, and it doesn't cost anything except a recording fee of, I don't know, $50 or something. And so that's how most couples own their home. And the same is true for owning other joint assets. You can have a joint bank account that automatically passes to the survivor of the two of you. Even non-spouses can have assets in joint ownership with a right of survivorship. That's what we call it when an asset legally passes to a surviving co-owner when one person dies. We call that a right of survivorship. And bank accounts are a good example of how that works. Now, what some people do is they take that one step further and they say, well, I don't have a spouse, but I've got my son Johnny, and I want him to inherit my bank account or my house. Why don't I just name him as a joint owner so that when I die, he'll automatically inherit it? Well, there's a long list of bad results from that. Big drawbacks, and I can't emphasize this enough. It's the most common and severe mistake that non-lawyers make, because they just think adding somebody to the title is a great solution. It is a solution in the sense that it avoids probate. Sure, that asset's going to pass to the son Johnny in my example, but here's all the list of other problems. Number one, that constitutes a gift. If you made Johnny a half owner of the home, that means you've given a gift to Johnny. Why does that matter? Well, folks, there's a gift tax. A lot of people don't realize this, but there's a tax at the federal level on the value of gifts that you make over the annual exclusion amount. Today, the annual exclusion is $16,000 per person. Okay, we usually don't go out and buy our kids $16,000 gifts for their birthday, so we don't worry about the gift tax. But if you add them to the title, you're giving them a gift of a half interest in your house. That's often over $16,000. And guess what? The gift tax is 40%. That's 40 of the value of the gift. So it's a crazy, scary thing, and you shouldn't add your kid to the title of the house. That's number one. Number two, it's irrevocable. Irrevocable. It means you can't get it back. So one day you like Johnny, you put him on the title. The next day he turns into a drug dealing crazy kid, and you say, you know what, I'm going to take you off the title. And Johnny says, nope, not signing anything, staying on the title. So you're stuck with him. Number three, it subjects the property to Johnny's creditors. So let's say Johnny makes some bad financial decisions, he gets sued. Those creditors get a lien, a judgment lien on the home that you thought was your home because you put Johnny on the title. Really bad outcome. Number four is it gives up control of the property. So you're going to need Johnny's consent in this example if you ever want to sell or refinance the property. And even for things like construction, if you want to get a remodel, the contractor is going to say, I need all the people that are on the title to sign the contract about the remodel. Next one is it creates the likelihood that profits from a future sale of the property will be hit with income tax. So right now, the law says that if you live in a property for 2 out of the last 5 years, you can sell a property and pay 0 income tax on the first $250,000 of profit that you made. And you can do that over and over and over. You can keep moving from house to house, live there 2 years, sell it, and pay 0 income tax on the first $250,000 of profit. But that's if you own the house yourself. If you own the house with Johnny in this example, you're not going to get that exemption. So it's a problem, and that's another reason not to do it. And then the last one is most important. There's a concept in the law called a due on sale. This is where the lender that gave a mortgage for the property has a little clause buried in their mortgage in the fine print that says, oh, you know, if you ever sell the property, the loan becomes due. And that applies to not just a sale of the property, it applies to any transfer of any interest in the property. Yikes. So what that means is by adding Johnny to the title, thinking you're going to avoid probate, actually triggers the due on sale clause. And when the lender finds out, they'll send you this letter that says, you know, that low interest loan that you got 3 years ago when the rates were low and attractive, we're pulling that loan from you because you violated the due on sale clause. So now you got to go out and refi at what, 5%? So it's another bad outcome. So all those reasons, don't add Johnny to the title. In my outline, I go on with other assets that typically do pass without the need for probate. Life insurance is a great one. And so are retirement accounts. Those are accounts that have a clause in them that says on the death of somebody, the benefits pass to a named person ahead of time. So that means like on our IRA account or 401k account, we should name somebody to receive the benefits. And when we do, those don't go through probate. They go directly to the beneficiary. Other assets, well, and I should mention what TOD means. TOD is the short version of transfer on death. You can actually go set up a bank account at most banks and ask to have a TOD clause added to your ownership. And that what that means is you still own your account, but you have an order in place with the bank that says, on my death, transfer this account to this named beneficiary. That is a great way to avoid probate on a bank account. And it doesn't give up control. So it's got all the good parts and none of the bad parts of adding Johnny to the title.
Hey, Steve, can I ask a quick question about that? If people are wondering, would that be a wise move to do because there are costs up front to get the probate process going, the estate process going? Would that be a way to help a family, like if they're not prepared to all of a sudden cough up several $1,000s to start the probate process? Would that be a good way to help ensure that if there's money in the bank that they have immediate access to help with this process?
I would say yes, but not for the reasons that you might think. It's a good idea to give them access to the funds as needed to pay bills. Mainly it's to pay bills, and especially to keep the lights on and the water running in the family home. So if the parents have died, we don't want those utilities getting cut off. And if the family members don't have the money, it would be great if they had access to the parents' bank account to pay those bills. But to answer your question about paying for the probate, no, the probate doesn't require any payment up front. And in fact, you're not allowed to pay the lawyer anything until the end of probate, when the court approves the lawyer's fees. So the probate process itself gets started at no cost, no upfront payment of fees. Of course, the lawyer that's taking on the probate is going to want to satisfy himself that there are indeed assets in this probate from which the lawyer will eventually be paid. So a good idea to be on your parents' bank account, so to speak, in order to pay bills if something happens to them. Also, in case they need help paying their bills while they're still alive and they need somebody to help manage their financial affairs. Okay, should I move on?
Yes, thank you.
Yes. So I mentioned in my outline here that there's a special rule that says any bank account of up to $25,000 can pass without the need for probate. So let's say that your parents pass away, they didn't own a home, they lived in an apartment, and they have a bank account, and the bank account looks like it might have to go through probate, but wait, if it's under $25,000, it's a matter of filling out a basic affidavit, and most banks will honor that. And the affidavit basically calls for you to certify that you are the heir and you're entitled to the assets. Okay, the next thing is a TOD deed. This is a type of deed that's relatively new. It was adopted in Oregon about 10 years ago. And it's a deed where the owner of a home can declare themselves still the owner, but they're mandating that the property automatically transfer at death, TOD, transfer on death, to a named beneficiary or several named beneficiaries. So the typical example is where father's deceased, mom's still alive, living in the family home, and she wants to avoid probate. So she records a deed naming her son Johnny as the beneficiary. So on her passing, Johnny automatically becomes the owner of that property without the need for probate. So it's a really neat deal because unlike where she just added him to the title in my other example, it's not a gift. It doesn't trigger a due on sale clause. It doesn't have all those disadvantages, and she can take it back. So if she changes her mind, she can undo this TOD deed. But as long as she likes the beneficiary that she named on the TOD deed, she can leave that in place. And then when she passes away, the beneficiary can just record a death certificate and automatically become the owner. It's a pretty neat deal. Big drawback, though, is the law says when there has been a transfer using a TOD deed after somebody dies, there's a period of 18 months that creditors of the decedent can show up and say, hey, I didn't get paid. So that means in this example, if Johnny sort of inherits the house on a TOD deed, he's got to stick around waiting for the 18 months to pass. Otherwise, he can't sell or refinance the property during that 18 months. He's kind of stuck waiting. So that's a little drawback. Let's see. Trust. Yeah, now we're at the bottom of page 4, and we finally get to the interesting discussion that a lot of people want to hear about, and that is, how do you avoid probate by using a trust? And what the heck is a trust anyway? So the terminology is that we now call these a living trust. It's because you set up this trust during your lifetime. It's living with you. And you can think of it as kind of like forming a company. You form this company called a trust, and it's really just an empty shell at first, but you know you're going to put assets in this trust. So bear with me for a moment. You form this trust, and you appoint yourself as the person in charge of it. That person is called the trustee, kind of similar to naming yourself as president of your own company. And so now you're in charge of your own trust, and you put your assets in the trust. For example, you have somebody prepare a deed to deed your home into the trust. You go down to the bank and you say, bank, I want to move all my bank accounts into this trust and other assets as well. Then when you become disabled or you die, the successor trustee that you've named in your trust takes over and starts managing your financial affairs for you, following the instructions of the trust. So for example, the trust typically would say, well, I'm appointing myself as trustee, but if I ever get to, if I ever lose my marbles and I'm not able to be my own trustee, then I name my son Johnny to take over as trustee. And when I die, I want Johnny to be the successor trustee, to be in charge of my estate. And when all the bills have been paid and the taxes have been paid, I want Johnny to give out what's in the trust to the following beneficiaries. Then you name out the beneficiaries just like you would in a will. Only the neat thing about a trust is it is a private contract, nothing more than a private contract, no court involved, no probate, no waiting. People can be distributing assets out of a trust on the way home from the funeral. So it's pretty quick and a pretty neat deal. And of course, you don't have to have a lawyer involved to help administer a trust. Sometimes there's complications that you need to confer with a lawyer for, but most of the stuff that a trustee does doesn't require a lawyer. So that's what a trust is all about. It's called a living trust because you create it during your lifetime, but then it continues on. Some people are reluctant to set up a living trust because they think they're giving up control, but they're not at all. You have every bit as much control over your assets that you put into your trust as you would if you didn't have a trust at all. But here's the catch. To avoid probate, you have to have all of your important assets in the trust. If you leave out any important assets, and by that I mean usually real estate or a big bank account, then though the omitted asset, that is the asset that you left out of your trust, has to go through the same full-scale probate as if you had no trust at all. So it's really an all or nothing proposition. You either put in everything in your trust and avoid probate, or you accidentally leave something out and you go through probate. But for most people, that's not a problem. In most cases, putting things into a living trust works great, and you don't have to worry about all the little things. It's not like you've got to, count how many plates there are in the cupboard and transfer all those in. We have sort of a catch-all transfer document that just says, yeah, all my furniture and furnishings, everything in my house, I'm hereby declaring transferred to my trust. So it's pretty easy to do, and this is why it's such a popular idea. I'm going to just gloss over real quickly this section 6 in my outline because it deals with the Washington Community Property Rules. And this gets into a little bit more complicated area, but community property is a concept that is surrounding the state of Oregon. So Washington is a community property state, Idaho, Nevada, California, we're surrounded. But we are not a community property state. We are a common law estate, like the vast majority of states in the country. What community property means is that when people are married, they automatically acquire rights in all assets, all marital assets, not just those that are titled in joint names. So even if, say you get married and your spouse has a bank account that they've tried to keep separate, it's probably not going to be a separate asset. It's going to be part of the community property that's going to pass half to the beneficiaries that the decedent spouse named, and the other half is going to the surviving spouse, no matter what. So it's something that creates some surprise outcomes for people, and you have to pay close attention to that. I'm going to slide on back to the subject of income taxes. I started talking about estate taxes a little bit back, and I didn't really mention income taxes. So I'll talk about that briefly. When you receive an inheritance, a lot of people ask me, do I have to pay income tax on that? And the answer is generally no. An inheritance comes to you free of income taxes. The one exception is if you inherit something that should have been taxed but wasn't yet taxed. And the most typical example is retirement accounts. Retirement accounts like an IRA or a 401k, those have pre-tax dollars in them, right? The whole point of a retirement account is to sock away pre-tax dollars and let them grow, tax deferred. Well, when someone dies, the income tax on that IRA is usually due. And usually it gets charged to the person that receives the IRA. So in a way, you could say the recipient does have to pay the income tax, but fortunately they get the whole IRA account, so they have money to do it with. But other than that, income taxes don't apply to an inheritance. So we don't have to worry about that. I talked a little bit about already the next type of tax on my list, and that's a gift tax. So this is only a federal tax. It's not a state tax. No state in the US has a gift tax, not really. And Oregon certainly doesn't, nor does Washington. So that means you can give away whatever amounts you want to your relatives or friends or whatever and pay no gift tax at the state level. But at the federal level, there is a gift tax. It's 40%, that's 40, and it applies to all gifts that are over the annual exclusion amount of $16,000. So, you know, if your parents want to make a gift to you to help you out, they need to keep in mind that there is this gift tax, and someone's going to have to pay tax on it if it's over $16,000. But there's two ways to avoid the gift tax. One is keep the gift under $16,000, and by the way, that's per recipient per year. So if your parents want to make gifts to their 3 kids, that means they can make 3 gifts of $16,000 each. And better yet, it's both parents. So that means they can make 3 gifts of $32,000 each and still fit within the exemption. Point is, that's a great way for parents to thin down their estate so that there's less estate taxes on their death. And so it's a neat way to do it. You can thin down your estate, your parents can thin down their estate while they are alive and pay no gift tax if they keep the gifts small enough. And then when they die, their estate is smaller so that the heirs, the family members, paid less estate tax. So it's a really great strategy to use for, you know, older folks that have an estate and I'll say surplus resources, as we say, meaning they got more money than they need to live on. They may as well start gifting it away to whoever's going to inherit it at their death. Okay. I already talked about the estate tax and how there's this exemption at the federal level, and then the Washington has an exemption of almost 2.2 million, and Oregon's exemption still remains down at a lowly $1 million. But here's the thing, that's $1 million per decedent. So if you have parents that are still alive, when the first one dies, they have an exemption of $1 million. When the second one dies, they have another exemption of $1 million. So you can see if things are structured right, your parents can pass wealth down to you of up to $2 million free of any Oregon estate tax. There's another neat rule that makes it very affordable, if you can put it that way, is the marital deduction. What that means is any amount of wealth can pass free of estate taxes to a surviving spouse. So that means even very wealthy people can leave billions of dollars to their surviving spouse and there's no estate tax. So that's the most commonly used way of avoiding estate tax. The problem is you end up overloading the estate of the surviving spouse so that when they finally pass away, their estate owes a whole bunch of tax. So that's why we estate planning lawyers do some sort of complicated maneuvering to make sure that both exemptions of $1 million each is being used. Okay, I'm going to move right along because we're getting near the end of the 1 hour. And then we're going to have a Q&A period where I can answer questions. A lot of people ask about the legal cost of wills and trusts. Now, I've already mentioned that wills can be done for as little as $400 or $500. You can also find some do-it-yourself materials online. But a living trust is a different animal. It's more expensive, it's more complicated, and typical fees might be anywhere from $2,000 to $4,000 to set up living trusts for a married couple. So there's a lot more work involved. But here's how the math works out. Let's just say you spend $3,000 today for living trusts for a husband and wife, and then they die and there's no probate. Compare that to the couple that spent, say, $600 or $800 on a pair of wills, then they die and the legal fees for probate are $3,000, $4,000, $5,000. So on balance, you can normally come out ahead if you have a living trust ahead of time. Even though it's more expensive up front, it's going to save a lot during the probate process. Now, does a living trust make sense for somebody that's young and healthy? No, absolutely not. I do a lot of living trusts, but I don't recommend them for young, healthy people. All they need is a simple will and they're done. But if you came to me and you said, you know, I'm 75, I don't have a great medical condition, and I have, you know, a couple $100,000 in the bank, I would say, let's talk about a living trust. So those are the candidates for that. Real quick legal update. There are some interesting little additions to the law that I mentioned at the end of my outline. Sometimes spouses have disputes about who's got the right to speak on behalf of both spouses. And the important thing to know here is that if there's been a divorce, even a separation terminates the authority of one spouse to financially bind both spouses. And it also revokes any power of attorney that you had previously signed. Another interesting thing is that the protection of tenancy by the entirety after transfer to a revocable living trust. So here's the way this works. When married couples want to avoid probate, they own their home as tenants by the entirety. Remember, I said that means on the death of one spouse, the asset automatically passes to the surviving spouse without the need for probate. Well, the other advantage of tenancy by the entirety is it makes your property very unattractive to creditors. Somebody that's owed money by one spouse has to wait to see if the other spouse dies first, and they don't want to do that usually. And so this TBE protection against creditors will continue in full force even if the married couple transfers their assets to a living trust, thereby terminating the TBE ownership, but they still get creditor protection. Okay. Last but not least, when a decedent owned real estate that was occupied by a tenant, the landlord-tenant laws might have made it hard for the landlord to evict the tenant. Well, guess what? During probate, the PR has full authority to proceed with evictions and do so on an expedited basis. So if you're the landlord, it's kind of good news if you die and your PR can take over. If you're the tenant, it's kind of bad news if your landlord died, because the PR gets to come in and take care of business and evict you if you're in violation of the lease. That's a new law, and that's why I mentioned it. So that brings us to the end of our outline, and I'm guessing there may be a question or two.
Yes, thank you for that, Steve. I know that was a fire hose worth of content, but again, this is being recorded, so you can go back and watch it later. So there are, Steve, there are roughly 30 some odd questions. So I'm just going to kind of work through them in order that they were received, and we'll get as deep as we can. And we'll try and wrap up around 7:45-ish, depending how you're doing. So this was back. Awesome. This was back earlier. One of the questions is, if you get a will prepared in Oregon and you move to another state, do you have to create or amend the will? In other words, moving to another state, what do you do?
That's an excellent question. And in this day where a lot of people are moving all the time, that comes up. The answer is that if a will is valid in the state where it was signed, when it was signed, it's valid in all 50 states. Now, would you want to have your will updated if you moved from, say, Oregon to Florida? Probably. You probably should have it looked at, because there might be some subtle little differences about the terminology and some of the features in the will. But fundamentally, the will is going to be legally valid and binding wherever you move, if it was valid at the time you signed it.
What if will has already been written up by an attorney, and I think the person meant to say the PR passes away, the personal representative? Do you have to write up a whole new will?
You don't have to write up a whole new will, but this is the reason why we anticipate these kinds of things when we write the will to start with. In other words, we don't just pick one PR. We pick a line of succession. And the best thing to do is to have 3 or 4 alternative PRs named right there in the will. You know, for one thing, a PR doesn't have to serve. And so you could name somebody in your will today that you thought would be a great PR. And then the time comes and somebody goes to that person and the person says, nope, I don't feel like doing that. I got better things to do. I'm not going to be somebody's PR. Yikes. So hopefully the will names alternatives.
Someone asked, is there a free will document that we can download, and do we need that notarized as well?
I can't point you to specific free will documents, but man, I'm sure if you put in a free will Google search, you get inundated with all kinds of proposals and offers. And I would encourage you to weed your way through the advertised sources, because they're going to want to charge you money. There's a lot of free source material on the internet, on the web, and you definitely can find something that will help you write your own will. But keep in mind that the will, again, has to meet all the right formalities. It's got to be signed and dated, and then it's got to be witnessed by 2 witnesses who sign, and then their signatures have to be notarized. So there's some things that have to be done, but if you meet those requirements, then heck yes, that works great.
Is there a way to argue that you did not correctly handle something regarding a bank account if you were the power of attorney of an estate? So in other words, I believe the question is, if you made a mistake managing something, how do you protect yourself or argue for a change if someone else didn't do it right?
Yeah, that's a really good question. And that's one of the first things that you got to keep in mind when somebody says, hey, I want to give you a power of attorney so you can help manage my bank accounts or whatever. You're taking on a responsibility when you accept that power of attorney. You're taking on responsibility in the form of a fiduciary duty. That's a really high duty. You got to be super careful and honest and transparent and thorough in performing your duties and doing the right thing with whatever you have power and control over. And if you don't, you can get sued. And it could be a lawsuit by another family member or a creditor or the tax authorities. So you can't take those things lightly. If somebody gives you a power of attorney to help them with their financial affairs, caution is the word.
This next question has to do with if there's an initial will created and we need to make small little changes, can we just scratch it out and initial it, or do you have to do an addendum, or what? Can you describe that process a little bit?
Yes, that's a very good question too. A lot of people think that by scratching things out on their will, they can make changes. Guess what? That completely revokes the will. If you make any marks on a will to change what it says, it revokes it. The law is very clear on that. It's a black and white rule. And I believe it's true in every state of the country. So don't write on wills. That's a terrible thing to do because it revokes the will. The better thing to do.
Does that include kids' crayons?
Not if they were accidental, but My advice on that one, very technical legal advice, is to keep the wills out of the reach of your children. But the answer is yes. If a will needs to be amended, nowadays, people do wills on computers, and so why not just reprint the darn thing? In the old days, we used to do an amendment to the will, and that had a special term called a codicil. A codicil is an amendment to a will. We don't do codicils anymore. We just reprint the darn thing, and with the change on the screen, and we reprint it, and then we get it re-signed. That's the best thing to do.
Okay, how about a estate tax question? If an heir is out of state, what state do the estate taxes go to?
Boy, that's a tough one. I mean, it's a tough answer, but the fact is that if you inherit from an Oregon decedent, you're paying Oregon estate tax. And so you could live in Texas, but if mom left you $1 million and she lives in Oregon, you're going to pay the Oregon estate tax on that $1 million. The tax doesn't really get paid by the recipient. In most cases, the tax gets paid by the estate itself before the estate wraps up and distributes out to the beneficiaries. So you could say that the estate pays the taxes, but guess what? They're deducting it out of the beneficiary's share. So it's as if the beneficiary is paying the tax. But just because the beneficiary is out of state doesn't mean the tax doesn't apply.
I think you've already answered this, but I just wanted to make sure, if we put everything in a trust, and do we have to take everything out of our name? So do we retain ownership of our name, or does the trust name go on the accounts?
The trust name goes on the accounts. And so yes, things that get put into the trust are no longer in your name. But you still have control over those assets because you're the trustee of your trust. So you're not giving up control, but you are using different terminology to establish that control.
Okay. Are spouses exempt from a gift tax when added to accounts and titles? I think you've answered that.
Spouses are exempt. Unlimited wealth can be transferred from one spouse to another at death, and also during lifetime, with lifetime gifting. So yes, there's no problem there.
This has to do with minors and TODs. Can you, or what happens if you set up a TOD with the minor as the TOD, or the recipient of the TOD?
Right. Somebody under age 18 is legally not capable of inheriting in the form of a TOD or under a will or a trust or whatever. So depending on the circumstances, we got to look around and figure out who can be the guardian of this person for purposes of this particular gift, whether it's a TOD gift or something else. But no, a person under 18 cannot inherit through any channels. And so there, in effect, an informal guardianship gets legally recognized, and somebody, whether it's a parent or an older sibling, is the designated guardian.
I think this person is asking, with a TOD deed, can two people be named?
The answer is yes. A TOD deed, like the one I described tonight, can name any number of beneficiaries, and you can get as complicated as you want. But keep in mind that each one of those beneficiaries has to cope with the 18-month rule that says they can't sell or mortgage their interest for 18 months.
This next question is really specific. I was a co-owner on my mom's car title. She passed away, so the car is under my name. Do I have to add this to the inventory in the estate? Since the will says we split 50-50, that which is in the estate, or does the car just stay with me? Or does the right of survivorship kick in at all?
But in that question, the short answer is car stays with you. It does not get added to the estate. owning title in a way that passes the ownership to a surviving co-owner overrides what the will says.
Similar kind of question related to vehicles. How do you put a vehicle into a trust?
Well, it's simple. You go down to the DMV and you have a copy of the trust document with you, and you say to the person behind the desk, I want to put this car title into this trust, and they'll hand you a form and charge a fee, and there'll be a transfer of title.
Perfect. Just a clarifying question, living trust versus living will, are they the same thing or are they different?
They're not the same thing. And I see some of you astute listeners are shaking your head, no, they're not the same thing. So you guys get extra points for being good listeners. So a living will is the old name that for the document we now call the advance directive or medical directive. It was way too confusing to have it be called a living will. So we don't even use that term anymore. It's the document that says, here's my healthcare decisions for myself, and here's who I want to make more healthcare decisions for me. That's the advance directive, used to be called the living will. Living trust is the kind of trust you set up to avoid probate. It's a trust you establish during your lifetime, and you put your assets in it and avoids probate. Just so you know, that's in contrast to what we call a testamentary trust. That is a trust that springs into existence only upon your death. And that could happen because lots of times a will might go through probate, and the will might say, and at the end of probate, Johnny's share does not go to Johnny, it goes into a testamentary trust for Johnny because he's reckless and irresponsible. Not that you'd say that in a will.
Can just an individual create their own trust, or do they have to hire a lawyer to do it?
An individual can create their own trust. It's tricky, and they may not do it right, but there's nothing in the law that says you can't try. And so if you do enough research online, you may be able to pull it off and avoid probate.
Can you name more than one person on a POD?
Yes. So a POD is usually the initials that we use to describe when a bank allows you to set up beneficiaries on a bank account. So it's a pay on death order in effect. And most banks will allow you to have multiple beneficiaries on that POD, but it's up to the individual bank. It's a private decision between the bank and its customer. So the answer is usually yes, you can.
Okay. This is another trust question. If you create a trust in Oregon and you move to Montana and die there, which state rules apply to the trust?
Very good. So for that, the trust, if it's well written, will specify what state law applies. And just so you know, when we prepare trusts, we always say the law of the trust situs shall apply to this trust. And situs is just the fancy word for location. Where is the trust located? Well, the trust is located wherever the trustee lives. So if the trustee moves to Montana and there's this magic language, then yeah, suddenly the trust is going to be governed by Montana law. But unfortunately, most people don't think about that when they draft a trust. They just say, well, I live in Oregon today, and I'm going to say Oregon law applies. Then when they move to Montana, it's chaos because some of the Montana laws are going to apply and some are not. And all I can tell you is it's unclear.
Another case to probably not try and write your own trust.
Another case.
Okay, this is a minor question. Can you designate certain age, or can there be specific parameters about how and when a minor receives funds from a trust?
The answer is yes. You can designate the age of the beneficiary as to when they will receive funds from the trust. But if you designate an age that's lower than 18, then that money is going to get legally intercepted by a guardian for the minor to hold it for them until they reach age 18. and then they're going to be given all the money at 18. Most typically what we see is parents wisely recognize that their teenagers are not mature and not even close to mature, even though they're almost 18. And so a lot of parents say, okay, if I die, I'm leaving, my estate in equal shares to my 3 kids, but it's going to be held for in a trust for them until they reach age 30 or maybe 40 or maybe 50. So yes, a lot of clients do that. They specify an age that the beneficiary has to wait until they get what's in the trust.
Simple tax question. Is there a certain document that needs to be filled out for the $16,000 gift?
If the gift is $16,000 or under per recipient, then no, there's no form that has to be filled out. If the gift is over that, there is a form that gets filled out, and this gets a little complicated, but it's the other rule that allows you to avoid the federal gift tax. One rule is keep the gift under 16. The other rule is, well, if you go over 16, you can avoid the gift tax by filling out Form 709, and in that form, you elect to apply part of your federal $12 million exemption. So, it's a lot of people are not, excuse me, a lot of people are not going to need their whole $12 million exemption. They may as well start using some of it during their lifetime. So if they say, for example, when they want to make a gift of $20,000 to Johnny to take to college, they just fill out a 709 and say, well, I hereby elect to use $4,000 of my 12 million so that this $20,000 gift to Johnny is exempt from gift tax.
Real specific question. During our refinance of the property, I was added to the title and took on financial responsibility for the property. Is the property still considered a gift?
Yes, if the owner allowed the speaker to be added to the title, the speaker that asked this question is receiving a gift, and the person that put them on the title is going to be hit with the gift tax if they didn't do things right.
I was interesting that this showed up, Q-tip trust. Not really just asking what it is, but it's a cost question. How much roughly is it to set up a Q-tip trust?
So a Q-tip trust is normally a feature of a living trust. Actually, it's a feature of both a will or a living trust for clients that have, a few $100,000 or more. What we do is we provide that the wealth passing from one spouse to another may be diverted into a Q-tip trust for the benefit of the surviving spouse rather than going to the surviving spouse outright. That's really what a Q-tip is for. It's an acronym for Qualified Terminable Interest Property. But there's a whole bunch of technical explanation that goes with that Q-tip wording. The short version is it's something we often set up in a will or a trust for the surviving spouse, so that when the surviving spouse dies, the Q-tip money is not included in their estate for tax purposes.
This is just a really practical, primer question in preparation for a will. Is there a resource / list guide that can help someone get everything together to take to a lawyer in preparation for creating a will?
I'll bet there is, but I couldn't point you to what that would be. You can probably imagine that my clients all just ask me, and I've got a form that I send them. It's about a 12-page questionnaire if they really want to go through all that. But most clients don't, and so I interview them and ask them the questions myself.
Okay. I'm not sure if you kind of touched on this. Do eviction laws change after the death of the landlord?
Right. So after the death of the landlord, the PR of the estate steps into the shoes of the landlord and can do all the same things that the landlord could have done had the landlord not died. And but the PR of the estate can do it more efficiently, meaning less wait times, less formalities. And so if a tenant is delinquent on rent, they could get kicked out faster by a PR than they could if the landlord were still alive.
Okay. And a subsequent to that is, would the PR be responsible for now the relocation costs of an eviction?
Under the right circumstances, the PR has to follow the same rules that a landlord would have had to follow in paying relocation fees. So yes.
Just a comment from someone said, be careful with free wills. I was disinherited because of a faulty free will my dad had signed.
Yes, and I've actually seen situations where family members have brought me the free will that their dad signed, and it did not achieve the outcome that they thought it was going to. And so that's not an unusual problem.
By the way, everyone, great questions. We're going to still keep rolling. I see there's more and more, so be patient with us as we kind of go into this. How often does a will or trust need to be updated?
So we recommend that a will or trust be reviewed about every 5 years, but we also sort of tell people, look, if there's been a significant change, we should get you in right away for a review. And by significant change, what I mean by that is either the birth of a new family member that you want to include, or the death of a family member that you formerly included, or a change in the tax laws, which are always constantly being discussed, and things like that. So changes of circumstances are a good reason for having things reviewed. Oh, and also moving, of course. But otherwise, if there's been no change, we still recommend about every 5 years you check with your lawyer.
Excellent. There's a question about taxes and fees, and I'm not quite entirely sure, but I'll try and get at the question. Can you tell me if you know when all the taxes and fees, I'm assuming associated around the probate process and someone passing away, when will they be eliminated from those who are alive? At what point is that part done and the heirs can move on?
So the very strict rule is that taxes are due 9 months after the date of death. And so most estates wait until the last minute to pay the estate tax, and then they pay it. And that, once the taxes are paid, even if they're paid early, that's when the heirs are free to take their inheritance and walk away. Now, strange, but this just happened. The state of Oregon decided to change the deadline. It's no longer 9 months, it's now 12 months. So we have this awkward situation for larger estates where there's a 9-month rule for the federal estate tax and a 12-month rule for the Oregon estate tax. But I think we're going to see most estates still trying to pay their taxes within 9 months, maybe sooner, so that people can move on with life and not have that out there hanging over their head.
This should be real quick. Is a verbal will good?
No, verbal wills are absolutely meaningless.
That was easy. Thank you. Should a couple in their 40s have both a will and a trust? Will a trust cover preferences for minor caregivers, etc.?
A trust normally is not where we put preferences for caregivers for minors. If somebody has a living trust, we usually have a separate standalone document where it's like a one-page thing where we just list who their preferences are for a guardian or conservator for a minor. However, there always is a will prepared, I should say routinely, lawyers prepare a will even for the clients that have a trust. Now, yes, a trust is supposed to avoid the need for a will because it avoids probate, right? You only need a will if you're going to go through probate. But here's the thing, we always prepare a precautionary will as sort of a backup. So if somebody has a living trust, they put all their assets in it, and if they pass away, that they didn't need a will, and the will gets, ignored. But if they pass away and they accidentally left an asset outside their trust, we want that omitted asset to move as efficiently as possible into the trust. And so there's a special type of will called a pour-over will, and the pour-over will has only one purpose, and it says, hey, I had a living trust, I meant to put everything in it. If I didn't, and it has an omitted asset has to go through probate, then this pour-over will at the end of probate says the omitted asset goes into the trust, but it's after the end of probate.
Okay. This is about intellectual property. If I have intellectual property that could be managed for profit by my heirs, would that be best handled with a will or trust? And what gives them the best immediate control of that intellectual property?
Either a will or a trust can dispose of intellectual property rights. That's the short answer. If the owner of those intellectual property rights wants to do something a little tricky and not just leave them outright to a beneficiary, but rather have the royalties from the IP be managed on an ongoing basis, then you definitely want to put that in the trust. But if it's just a simple matter of saying, hey, I wrote a book, I'm leaving all the copyright royalties to my son, Johnny, that can be done in a will.
Back to TOD. Does a TOD deed cover all assets or just residence? And second part is, could TOD deed do what a trust does?
The first question is, the answer is a TOD deed only covers real estate. It can cover your home, it can cover your rental property, but it only covers real estate, meaning land and building. Can a TOD deed do what a trust does? The answer is no. A TOD is sort of a simple, blunt instrument, and it just simply says one thing. On my death, I want my real estate to go to these named beneficiaries. Whereas a trust can do all kinds of tricky things, like I want this property held in a trust until they reach age 30. I want the property to be divided into unequal shares. I want to put in some rules about what the recipient can and can't do with the property. I mean, there's a million things you can put in a trust that you cannot put on a TOD deed.
Advanced directives. Does an advanced directive have to be added to will documents? Is the paperwork at the attending hospital sufficient?
Well, the paperwork at an attending hospital usually means somebody's filled out the advanced directive at the hospital and the hospital has it. And yes, if that's the only medical provider that's ever going to need it, then sure, that works fine. But nowadays, people are moving around and they might get injured when they're out on vacation and not at that hospital. So that's why we recommend that clients sign an advanced directive at the same time they sign their will, and that copies of those things are provided to various family members so that the family members will know what the wishes were.
Okay, similar vein in the medical directives, how important is it also to have a POLST on file, POLST?
Right. So a POLST is a whole separate document. It's an acronym for Physician's Orders Regarding Life-Sustaining Treatments. And it's just that. It's not a lawyer document. It's a doctor's order, basically. And doctors are supposed to sit down with their patients that are either terminal or senior, and together they fill out the POLST. And it says such things as, I don't want to be resuscitated, or I do want pain meds, I want to be kept comfortable, or whatever. It's a lot like the advance directive, only it's much more specific, and it's signed by a doctor with the input from the patient.
Excellent. I think you've already addressed this. Is adding your spouse to the house title considered a gift?
Correct, it is not.
Okay, this is back to gift taxes and inheritance tax. Is there a specific inheritance tax, or is it just a gift tax? And are all inheritances a gift, even to children?
So there's this whole terminology thing that gets really confusing, but the word inheritance tax and estate tax is kind of interchangeable. Different states call it different things, and there's some subtle reasons why, but the bottom line is it's a death tax. It's a tax on wealth owned at death. And I'm not sure about the rest of that question, what else they were asking, but yes, the death tax applies. Once you're over that exemption amount, it applies regardless of who's inheriting, even if it's kids, not the spouse. Of course, spouse inherits exempt, is exempt from estate tax.
A similar vein to tax issues, can property be moved to a living trust to avoid gift tax?
No, the answer is no. Putting things in a living trust is a great way to avoid probate, but it has nothing to do with taxes.
So same, I see someone asked a similar question. Does a living trust avoid all taxes? You said no.
And yet the answer is no.
Okay. There's a tricky question, debating whether or not to ask it. What happens if you're in a coma, and I'm not making this up, and will this be considered an executor's responsibility to carry out their trust wishes?
Well, yes. I mean, trusts are always written to say that the person who created the trust is still in charge of their trust until they're not able to be in charge of it anymore. And that's one of the main features of a trust, is to say who your successor trustee is, even if you haven't died but have become disabled. So if you're in the hospital and you're in a coma, you know, hopefully your successor trustee, the person you named to take over as successor, is made aware of that, so they can step in and say, okay, I'm the new sheriff. I'm the one in charge of this trust.
If the recommendation is to review a trust every 5 years, is there a fee to just review versus rewrite?
Yes, there is a fee. Short answer. It's usually a pretty minuscule fee if there are no changes. And I like to meet with clients actually every 5 years or more, whenever they want to. And it's really more of a social visit than anything. But if there's some significant legal advice being discussed, then yes, there's a small charge for that. But if it's really just yeah, nothing's changed, everything looks fine to me, most of us don't charge for that.
Got it. So you're just paying for your time. The longer you sit with someone, typically the longer that costs. That makes sense.
Yeah.
Pour over will puts admitted assets into the trust. Can you choose to not go through the hassle of moving all your vehicles in, for example? So if you wanted 2 vehicles in the trust and you wanted 2 out, for example.
Yes. Short answer is yes. You know, vehicles are one of those exceptions where you don't have to put them in the trust to avoid probate. Remember, the whole reason to put things in the trust is to avoid probate, right? Well, there's some assets that just don't go through probate, and vehicles are one of them. In Oregon, the DMV has a nice, neat procedure where you sign an affidavit certifying that you're entitled to the title because the owner died. And so we rarely tell clients to put a car into their trust.
Business owner question. Does it make everything more complicated or change whether you choose a will or a trust if you own a business?
Yes and no. I wish there was a simple answer, but yeah, there's some pluses of putting it into a trust, but there's also some minuses. One of the biggest problems is that when you put a business in a trust, you have to, you're supposed to get the consent of your co-owners. Now, if you own a business all yourself, yeah, it's the right thing to do. If you're the single owner of a business, by all means, put it in a living trust, avoid probate, and don't worry about it. But if you've got co-owners, they're going to want to have something to say about who takes over your interest when you die, and they're going to want to see the living trust, and that means they're going to want to, get into your maybe personal information. So it really depends on what the co-owners want to have, what rules the co-owners want to have in place if somebody dies.
Okay, thank you. This is a gift tax question. Maybe tipping into the tax avoidance space, but I'll see. I'll let you interpret that one. Is there a way to gift money under $16,000 every year into an account for someone, which cannot be touched until after death to avoid the gift taxes?
Yes, and I love this question because it's very insightful. I recommend this to clients all the time. So let's say mom and dad have surplus wealth. They don't need it all. But on the other hand, they don't really want Johnny to have it because he'll go out and blow it on sports cars. So they want to put it somewhere in between. So it's out of their estate, but not in Johnny's hands. And yes, there's a well-worn vehicle for that. A lot of us call it a gifting trust or a receptacle trust. Anyway, it's a trust, and it's a perfect solution to that very problem. The one catch is that you can't be the trustee of that trust. You've got to pick another person or a family member or your lawyer or whatever to be the trustee. But yes, it's a great way to thin down your estate, gifting into the trust without letting the recipient have access to the money until some future date.
All right. Another question. Can we put cryptocurrencies in a living trust?
I think the answer is yes. I can't tell you that I've done it, but I know that cryptocurrencies are usually held in an account at a cryptocurrency trading facility, and there's nothing wrong with having that account being titled in the name of your trust, just like you would with any bank account.
Really specific question. Has to do with like customized vehicles and real like specific work done that's rarity. Should we put these kinds of things into a trust?
Yes, I see that question and I agree completely. Important vehicles should be put in the trust. Important things or very, very valuable things. But our everyday car that we drive to the grocery store, that does not need to go into the trust.
Those are the questions that I have seen. Becca or Tina, are you seeing any other questions? Okay,
Well,
last call.
I'll
Go
just
ahead,
interject here. I did see a question that we didn't go back and talk about, but I think it's intriguing. If your assets are taxed at death and then you miraculously come back to life, does that mean the tax man has to pay you back? That is a really good question. Putting aside reincarnation for the moment, I've not encountered that before, but I think it should be a refund situation where the tax man has to pay you back. That's just my opinion. Okay.
Right. That's good. All right, one more question, and then kind of last call here. Can you designate how funds are to be used in the trust, i.e. life insurance policy to be invested for child later in life? So how much control can you put within a trust?
A lot. And that's a really good question. And that's a great technique to mandate that the trust buys something for the benefit of the beneficiary without having those funds become available and vulnerable to that beneficiary. So yeah, buying a life insurance policy with funds inside of a trust is a great solution.
Excellent. Any other questions? And Steve, if people here would like to reach out to you outside of the Birch context, is there a good way for them to reach out to you?
Yes, I invite emails. I answer dozens of emails every day, and I'm happy to answer short little questions like the ones we just went over. And if questions raise more complex issues, my answer will say, we really need to sit down and talk because that question raises a bunch of complicated issues. I do meet with clients either by Zoom or at my office or just have phone conferences. And I do estate planning for both Oregon and Washington residents.
Excellent. Thanks, Becca, for putting that in there. Okay, just saw a couple questions just pop in real quick. So I'll just take these last 3 questions and we'll wrap up, Steve.
Okay.
Are you available to talk wills trust with someone being resident of Washington? In other words, do you meet with people who are across the river?
Yes, I have ample expertise about Washington law for estate planning, just like I do in Oregon. Technically, I'm not licensed in the state of Washington, so I can't physically drive across the river and meet with somebody. But I can certainly talk to them on Zoom and on the phone, or have meetings here at my office where I can advise them about the whole spectrum of Washington estate planning.
And just 2 more questions. How hard is it to add and remove assets from a trust?
Generally speaking, it's super easy. It's just as easy to take them out as it was to put them in. So for example, if it's real estate, it's a simple deed, signing of a deed. And if it's a bank account, it's usually going down to the bank and saying, hey, I'm trustee of my own trust, and now I want you to retitle this account in my name personally because I'm taking it out of my trust.
And last question, I think Tina and I have had this conversation before, families. Would the will allow the guardian of your minors access to the funds, the inheritance, for the kids to help pay for the child's needs?
Not automatically, but yes, if you structure the will that says the money is to be made available to the guardian of your minor kid, then yes. But if not, then the guardian is not automatically entitled to reach into your estate and take money, but they'll probably have to go to court to get a court order to spell out how much money they get to take for the care of the minor kid.
Excellent. Well, Steve, we just want to say thank you for taking your evening tonight to shed just a lot of insight. And thank you everyone for your awesome, real specific questions. Hopefully that blessed everyone. Again, Steve Bennett from Farley, Wada and Witt. His email address is in the chat that we just put in. Again, thank you everyone. Thank you, Steve. We really appreciate you doing this. And everyone, we will get the recording out to you by the end of this week. So you'd be looking on the email from Becca, and have a wonderful evening. Again, thanks everyone, and thank you, Steve.
You're very welcome. Good night.